But I'm really delighted to be here, delighted to meet Michaela in person for the first time. So as you mentioned, we've just started up this study group with the ILA on individual responsibility in international law, and I'm very excited about the ongoing and future work of that group. Interestingly, to try to bridge maybe the last presentation and this one of the books you mentioned I wrote some time ago, but it's called The Paradoxes of Nationalism, and actually about this question of the relationship between the state and the popular will. But where I actually thought maybe we were going with the discussion of revolutionary movements is a point more closely related to my presentation today on this question of attribution. Attribution of acts of officials to the state. And the reason I mention this connection to revolutionary movements, although not necessarily only nonviolent ones, is as the special rapporteur, who we're so honored to have with us today, noted in her most recent fourth report, the draft articles on state responsibility that the International Law Commission developed in fits and starts over a 40-year period, ultimately adopting them in 2001. So those of you who've studied international law, maybe with Professor Helfer, may have looked at some of those draft articles, again, developed under the auspices of the International Law Commission, come up with a series of criteria based on which acts, inevitably performed by individuals, because at the end of the day, any entity we all acknowledge can only act through individuals, a series of criteria by which we determine that those acts are imputable or attributable to the state for the purposes of state responsibility. Now, as I'll get into the paper in a little bit more detail, the notion of state responsibility itself changed and was contested over the years. There was initially some notion that there might be a notion of state criminal responsibility that ultimately was rejected. But the idea of responsibility that we have in the draft articles is one of a duty to repair, a duty of reparation that the state possesses by virtue of acts, certainly acts of its agents, certainly authorized acts of its agents, but as you know, if you've read the draft articles, also unauthorized acts of state agents, and even, to tie into one aspect of Elizabeth's presentation, even acts of, for example, insurrectional groups that were not only not acting for the state, but in fact were acting against the state, if the group ultimately succeeds in taking power. So the draft articles on state responsibility have this very expansive definition of the circumstances in which the acts of individuals will be attributed to the state. I'm a sucker for history. I have a long article on, as I was mentioning to Kurt, well, Kurt knows, but I was raising this morning on late 18th century cases brought against foreign officials in U.S. courts, where those of you who are here, I mentioned that the State Department back then didn't think it had any constitutional authority whatsoever to instruct a court to dismiss a case on immunity grounds, be it status-based or conduct-based immunity. But regardless, sort of digging into the history, I think, of some of these principles is very instructive, not because we need to follow historical understandings point by point. To the contrary, in fact, this is a dynamic and evolving area of law. That's why it's such an interesting topic for a symposium, but because it helps us understand the rationale behind some of the rules that we've inherited. And certainly the rationale for the broad attribution rules, and again, I'll get into more detail in this in the paper, but sort of by way of summary, was twofold. All right, first of all, quite frankly, it was an imperialist rule, all right? The United States had a number of arbitrations, and France had some arbitrations in Latin American countries in which French and American nationals had been harmed on the soil of those countries. And as you may know, principles of state responsibility initially were purely responsibility vis-a-vis aliens, right? So aliens on your territory. And so in those arbitrations, right, the determination was we want a broad attribution rule so that injuries to these aliens could be redressed, right? And so if an alien was injured, even if it was not by an authorized act of a state agent, if there was any connection to the state whatsoever, right? The idea was these Latin American countries, there are a couple of adjudications, for example, involving Mexican liability. The host state, as it were, would be found responsible under international law and have to pay reparations to the state of nationality of the injured alien, be it the United States and France and so forth. So this is the origin of this principle. Now, viewed a little less cynically, maybe, so not so much in the prism of the power dynamics of post-colonial relationships, or even colonial relationships, the notion was we want to have the broadest scope of reparation possible. Because, as the draft articles make clear in the commentary, any other rule would be highly susceptible of manipulation by the responsible state. All the responsible state would have to say was, oh, no, this action was beyond the scope of authority of our official. Oh, no, our official had no authority to commit this act, thereby absolving itself of responsibility. So the idea of a broad attribution rule was actually to create a broader scope of the possibility of reparation in the situation of harms to aliens. Now, those of you who've maybe read the Jones decision by the UK House of Lords will note the irony here is that this broad attribution rule in more recent jurisprudence has been used not to expand the possibilities of reparation and redress for injuries, but rather to contract it. And how has that worked? Well, the Jones case in the UK House of Lords was interpreting and applying the UK State Immunity Act. And I heard this morning about the US Foreign Sovereign Immunities Act, the FSIA, the 1976 legislation that implemented, as one of the students mentioned, a restrictive theory of foreign sovereign immunity, saying going forward that US courts would apply the principle that a state conducting sort of public acts would be treated as immune, but a state or its agencies or instrumentalities performing commercial activities with a certain nexus to the United States would not have immunity in US courts. The FSIA, the US version of this act, as we found out in the Samantar case, does not cover actions against individual officials. And again, not to repeat the discussion from this morning, but there may be certain cases in which the suit is actually seeking the assets of the state, in which case it is essentially an act against the state and will proceed under the FSIA, but by and large, the regime for individual officials is a common law regime, not a statutory regime. That is not the case in the United Kingdom, or for that matter, in Canada or Australia. So those states also have state immunity acts, but those acts are drafted very differently. Number one, unlike the FSIA, they explicitly exclude criminal proceedings. Now, this wasn't very much in the minds of folks in the Samantar case, or at least didn't come through in the reasoning, but actually, if the FSIA applied to individual officials, because it does not explicitly exclude criminal proceedings, it would presumably prevent criminal proceedings in US courts against foreign officials, which is certainly not anything that the executive contemplated, and certainly not Congress at the time of its drafting. There are also explicit references in those other state immunity acts to things like head of state immunity. So although there's still some ambiguity in the language, and although there certainly is language in the Jones case about international law, it really was fundamentally an interpretation and application of a domestic statute. The logic in the Jones case, which is cited in a variety of contexts, was that in the civil context, so again, criminal proceedings outside the scope of the State Immunity Act, and as we all know from the Pinochet case, in fact, the UK was one of the first high courts to say that there shall be no immunity for torture, at least where the states involved have ratified the Convention Against Torture. The Jones reasoning, in Lord Bingham's opinion, said in a civil case, the state is indirectly impleaded by a civil suit against the individual official if the acts upon which the suit is based are attributable to the state. Now, that has some superficial logic, but if you look to the draft articles on state responsibility for principles of attribution, you see that, in fact, that can't be the case. And I've been reassured today to hear from a number of speakers that they don't accept the implications of this notion that any act that is attributable to the state must therefore be covered by what we've called conduct-based or ratione materiae immunity because those rules of attribution are so broad. So if we're not going to use principles of attribution, then what do we use? And in the paper, and again, my comments have wandered a little bit from that because, after so many wonderful speakers have gone, I wanted to say something that helped move the conversation along. But in the paper, what I suggest, and this idea is not new to me at all, but is that we should think of three categories of acts, right? There are acts that are solely attributable to the state, and for which the state alone bears international responsibility. And in fact, in the question this morning about commercial acts and how the restrictive theory operates vis-a-vis individual officials, I think this is essentially the notion. The notion is that individual officials don't bear personal responsibility for entering into commercial transactions on behalf of the state. If I'm a state official, and there's actually one Irish case from the 1970s to the contrary, but by and large, if I'm a state official, engaging in contractual relations on behalf of the state, I don't think my bank account is going to be put in jeopardy if something goes sour in the transaction, right? This is the state's responsibility. I'm signing the contract or the purchase agreement or what have you, because that's the only way the state can sign something. It doesn't have any other sort of way of acting, but I don't bear personal responsibility for those acts. So those are what I've called Category 1 acts, for which the state is the real party in interest. For example, if an official were named as the nominal defendant in a suit. Then, if we skip ahead to Category 3 acts, those would be those for which the individual alone bears responsibility. So there I'm thinking, of course, that anything that a private citizen does, something that a state official does purely in her what we call private capacity, take your example, vandalizing the neighbor's property, or shooting somebody in a fit of pique with no use of state authority or not even a gun provided by the state, this sort of thing. Category 1, Category 3, fairly straightforward. The problem is Category 2, right? Category 2, which the special rapporteur spoke to us about at lunchtime, and which Michaela's remarks this morning also invoked, where you have what the special rapporteur has called, single act dual responsibility. The same act generates both personal responsibility for the individual, as we now know do all international crimes, and yet at the same time are clearly also attributable to the state. And so what do we do with those acts? And I think this is still a puzzle, and I think it's a puzzle that the fourth report and the draft articles that were adopted this summer don't yet resolve. At least I hope they don't resolve. I hope that by saying, I hope that by saying in the exercise of state authority, we haven't quite yet clarified whether that means in the exercise of actual authority or apparent authority, because I think that there are some really still tricky conceptual questions to muddle through on that point. Now, to the extent that the historical debates on attribution are at all relevant, it is very clear that any act performed with either what we call actual authority, that means the state has invested you with the authority to act, and by the way, you're not only, of course, invested with the authority to perform internationally lawful acts. I mean, the government of Nazi Germany gave actual authority to its agents and officials to engage in genocidal acts, right? So you can still perform international crimes with actual state authority, although many have made the point that on an international level, perhaps there's no such thing as actual authority to commit an international crime. But I don't think that's where you can draw the line, because again, internally, from the point of view of a state's internal law, that may be actually authorized. And then we've got all these acts committed with apparent authority, right? The tortures that are, collateral to state policy, if not actually in pursuance of state policy. I'm just going to cite to you, because I promised a little history, sort of two somewhat contrasting visions of the scope of attribution. Again, the draft articles embrace an expansive scope, and at the end of the day, I don't think the position they take tells us much about what to do about ratione materiae immunity anyway. But here are two, just for your thought, two potential characterizations. So these acts actually were both injurious acts by U.S. officials, as opposed to foreign officials, but that harmed aliens within U.S. territory. So one was an act by a U.S. deputy sheriff who shot a British subject in New Mexico, and the other was the act of another deputy sheriff in Texas who assaulted a foreign consul. So I guess our deputy sheriffs have not always been sort of gently disposed towards aliens in their territory. In any case, the first one, the Tunstall case, the U.S. Secretary of State actually took the position that anything that was not strictly part of the deputy sheriff's functions, in other words, in this case, serving a civil writ, was outside the scope of the sheriff's authority and fell outside the scope of the United States' state responsibility. So what the Secretary of State said at that time, Thomas Bayard, he said, killing in personal malice by an officer of a defendant in a civil process in such officer's hands, such killing being subsequent to the execution of the writ, is as collateral to the official action of the officer as would be the commission of arson against the dwelling or rape of a member of the family of the party by such an officer after the civil process had been served. Now, that's a very narrow conception, right? You're saying this defendant is in the officer's hands, but once they've served the writ, they can kill them, they can commit arson, they can rape the members of the family, and that will be, falling outside both the scope of authority and also the scope of state responsibility. Well, that position was decisively rejected by a number of arbitral tribunals subsequently, and also by the draft articles. And what we had instead was this much more expansive conception, exemplified by this Texan case, in which a deputy constable in Texas basically had, again, a personal grudge against this Mexican consul, said the consul hadn't done enough in Mexico to arrest someone there who was allegedly responsible for the death of one of the constable's relatives, and so sort of took the occasion of having to serve a writ on the Mexican consul in Texas, showed his badge and then, beat up the consul, right? Essentially, so personal assault. And here, there was found to be state responsibility of the United States, even though this wasn't an authorized act, right? He showed the badge, you beat him up, he was under apparent authority of this official. But quite importantly, just because the United States had to pay damages to Mexico for this assault did not mean that the individual bore no responsibility. To the contrary, the individual was also fined in the circumstances. In this case, the Malane case, was cited by Lord Bingham in the Jones decision, or actually maybe it was Lord Hoffman's speech, I'd have to go back. It was cited in support of the Jones rationale that even though these ultra vires acts are attributable to the state, but again, just because they're attributable to the state does not mean that the individual necessarily gets immunity or is shielded from consequences. It simply means that the state also bears responsibility. So where does that leave us? Well, it leaves us with some really hard choices. It leaves us with some really hard choices because if we accept, as I think most people do and most people who have spoken today do, that individuals bear personal responsibility for their acts, even if they're acts that are committed on behalf of the state with actual authority or apparent authority attributable to the state, how do we impose consequences for those acts? And again, one of the things I hope our study group will look at in more detail is whether there's really a meaningful difference between civil responsibility and criminal responsibility, this duty of reparation versus being subjected to punishment. But in particular, what we need to think about is a question that surfaced this morning. Is it solely the courts of the official's own country that have the ability to impose consequences commensurate with that personal responsibility? I think we're all pretty clear that the answer is no. That is not an exclusive jurisdiction. Certainly the territorial state has jurisdiction, the state of nationality has jurisdiction, but in recent decades we have seen that international tribunals also have jurisdiction, whether they're ad hoc tribunals created by the UN Security Council, whether it's the ICC that has then jurisdiction over either states that are party to the Rome Statute or states whose cases have been referred to the ICC by the Security Council. And then we do have these hybrid tribunals that the special rapporteur mentioned where, as you may know, in the special case of the Sierra Leone tribunal said, we're more like an international tribunal than a domestic tribunal for immunity purposes. We're not going to recognize immunity defenses. So we know we have the territorial state or the state of nationality of the alleged offender. We know we have international tribunals. And the question is whether we also have the ability of foreign states to impose consequences in this sort of horizontal way that has been described. And then we further bifurcate. Does it matter if they're civil consequences or criminal consequences? Is that really a distinction with a difference? And so I think that that's really where we need to focus. And because my time is limited and because I want to certainly leave time for commentary and questions, I think what I'd like to emphasize is a point I tried to make in my intervention this morning as well, which is that immunity can't do all the work here. So, it seems very appealing to have a blanket immunity rule. Anything attributable to the state, there's immunity. Great, wash your hands of it. Look at the draft articles on state responsibility, we're done. It's essentially the Jones approach, which we've all said it can't be correct, right? Just look at the draft articles, it can't be correct. On the other hand, there's a temptation to say anything you do that is ultra vires, either of your domestic authority or of international authority or some combination, no immunity. And there, you're not going to get buy-in. Whatever you think about the appropriate, you're not going to get buy-in because the possibility of, spuriously motivated prosecutions of, I should specify here, the status-based immunity, the reshede persona immunity, I think gets you a long way towards addressing those concerns, especially when you add in the special missions. But I do think that we need to think seriously about the challenge that John Bellinger posed before the lunch break about reciprocity concerns and, what would you do if you were the legal advisor. But I also think that we need to think about this both in terms of jurisdiction and immunities. So the Sixth Committee, as we've heard, is also tearing its hair out about universal jurisdiction principles, and I'm certainly not going to try to go there in the 45 seconds left. But I think there is some relationship, right? I mean, the cases that seem to give us the most pause are these ones involving what in the US we call tag jurisdiction. Well, tag jurisdiction is actually not recognized internationally by and large, particularly in civil cases. So there, the problem seems less to be, whether or not we give immunity, and more the fact that we're in the situation to begin with because we're recognizing tag jurisdiction over individuals who are passing through. Similarly, right, some countries whose assertions of criminal jurisdiction we might be worried about, we might be less worried about their assertions of criminal jurisdiction in true cases of international crimes that everyone would agree need to be redressed, and maybe more so if we see that there's some political motivation or some lack of due process, or death penalty for minor crimes, other sorts of things. So I was intrigued to hear that your work will involve at some point also these what we call procedural elements, or what the ILC called in state responsibility. They didn't get into what they call the adjectival aspects of the topic, but I think that those aspects are also important, and so to the extent that we can maybe discuss, as we have today, immunity, which is a very important topic, but recognize that immunity itself can't do all the work and that it operates in tandem with and interaction with all of these other doctrines. So with that, I'll invite Beau's comments from beyond and then comments from the audience. Thank you.
So before I magically become Beau Rutledge, I just want to say that I think you get a sense from the kind of both the substance of Professor Keitner's presentation and the the energy with which she attacks these issues, that she really has spent a lot of time going very deep, not just historically, although that too, but also conceptually, in trying to unpack a number of doctrines that just didn't collide in the same way in 100 years ago, 200 years ago. And now they have. And ultimately, I think you come down to a series of choices. And I think that the type 1, type 2, and type 3, I think are very helpful because I think they give us boxes to put things in and at least can clear some of the underbrush. Because I think that's right, that there are such categories conceptually. We may disagree about the boundaries between them and the jurisprudential or methodological tools that we use to define those boundaries. But I think it's useful to have those categories. And I think there has been a little bit of loose analysis by courts in picking and choosing paradigms that haven't been thought to be separate, which I think, in fact, probably are. So in any event, it's obviously always a treat, Chimène, to hear you. So now I'm going to become Beau Rutledge, and then I'm not even sure what I'm about to read. So it's so recent that it just came in. So, right, it will be interesting to see. Right, so Professor Keitner's paper explores important but under-theorized puzzles of foreign official immunity, namely the extent to which acts of government officials can be attributed to a foreign state, and second, implications of such attribution. The starting point is the old saw that states formally do not act on their own, but instead necessarily must act through constituent individuals who comprise the governmental corporate body. One might presuppose then that the space between individual responsibility and foreign state responsibility simply doesn't exist. Conduct of individual government actors must necessarily be then attributable to the state on whose behalf they act, with the only residual question being the scope of authority of the individual actor. The classical, if oversimplified, view of Lady Hazel Fox captures the essence of this approach. Yet, as Professor Keitner explains, and folks in this room know, he said folks, not me, both international law and domestic law, especially following the Supreme Court's turgid decision in Samantar, lack such lucidity. Of course, opacity of attribution principles is hardly unique to international law. Other fields such as criminal law, tort law, corporate law, and official immunity all contain attribution principles that do not impute individual conduct to the corporate actor, state or otherwise, on whose behalf she allegedly acts. Situating Professor Keitner's attribution puzzle within this broader jurisprudential framework helps to reveal precisely why such subtle but less definite rules emerge in the first place. Strong attribution doctrines, like respondeat superior in tort law, incentivize the corporate body to regulate the individual's conduct. Weaker attribution doctrines, like corporate criminal liability, sometimes attempt to do precisely the opposite. That is, they attempt to decouple the individual's incentives from the incentives of the corporate body so that the individual elevates his or her own interest over that of the corporation. In other cases, weaker attribution doctrines reflect countervailing policy concerns that justify wholesale attribution of individual conduct to the corporate body. And he gives as an example here municipal liability rules under Section 1983 Civil Rights Litigation. The foregoing examination of corporate imputation doctrines and their limits in other contexts sheds light on the attribution puzzle that Professor Keitner's article explores, especially the Category 2 cases that she finds the most interesting. Are the rules governing such Category 2 cases best understood as efforts to optimize conduct regulation, whether by forcing states to regulate individual conduct or forcing individual government officials to police themselves? Or instead, do the rules governing these Category 2 cases reflect an effort to reconcile the virtues of a total attribution rule with countervailing policy considerations, such as, for example, the specter of comedy always looming involving foreign sovereigns? Begin with Professor Keitner's thoughtful analysis of the rules governing attribution of ultra-vires acts. Here the question is one of treatment of the state, or, put more abstractly, the corporate body, that cannot act except through its individual members. As a matter of first principle, one might turn Lady Fox's precept on its head as follows. If the state official is acting beyond his or her authority, then no attribution should occur, full stop. That simple rule, the drafters of the ILC articles on state responsibility recognized, would have profoundly troubling implications. As Professor Keitner notes, it would easily enable states to shirk their responsibilities under international law by seeking refuge in their domestic law constructs about the scope of that liability. One might overcome this problem by adopting another simple rule at the other end of the spectrum, and that is attributing the ultra-vires acts of state officials to the state irrespective of their authority. That would avoid the, quote, refuge in domestic law problem, but generate its own parade of horribles. Not only would it radically rewrite the Westphalian structure underwriting most international law obligations, it would also impose a virtually unwieldy and likely ineffectual obligation on the corporate body. Thus, the attribution principle contained in draft Article 7 reflects a delicate, if clunky, compromise designed to incentivize conduct regulation by states, but not too much, and to embed the countervailing policy considerations into any attribution analysis, not unlike, he says, the pattern or practice requirement in municipal liability under Section 1983. Consider next Professor Keitner's discussion of the relationship between attribution and immunity. Here, while she explores a different puzzle in the attribution problem, the analytics are closely related to the puzzle just discussed. The question again is one of space. In situations where individual conduct is attributable to the state, is it nonetheless possible for the individual not to enjoy the blanket of the state's own immunity? Lord Bingham's answer encapsulates Lady Fox's simplified response to the first question. There is no such space for immunity. That there is no such space for immunity necessarily follows the attribution principles. As with the question of ultra-vires acts, critical scholarship in this field has sought to replace this simplicity with a more value-sensitive and nuanced approach. Increasingly, one witnesses efforts to decouple the two such as in the area of individual responsibility for acts of torture. Like the preceding puzzle, the analysis centers on the acts of the foreign official. Unlike the preceding puzzle, the solution trains not on the, quote, authority, actual or apparent, of the official, but instead on the precise type of act, torture or otherwise. Reflecting again on the broader jurisprudential question of attribution to a corporate body teaches us why this might occur. Decoupling attribution from immunity, the international order imposes a type of conduct regulating duty onto the actor, most likely to respond, decoupling attribution from immunity, the international order imposes a type of conduct regulating duty onto the actor most likely to respond to the regulation, here the government official herself. This move aims to encourage the state actor to respond to a supranational ontology, much like corporate criminal law doctrines aim to provide the employee a set of conduct regulating incentives that supersede the incentive structure of the corporation. In sum, Professor Keitner has once again distinguished herself as a thoughtful contributor to a ripe debate in a field of foreign official immunity, and I'm grateful to offer these comments to what undoubtedly will be a robust conversation on her ideas.
Thank you, Larry, for reading that.
Thank you, Dean Rutherford. I don't know if there's anything you want to respond, or should we just open up?
I'm happy to give time to...
So we have some time for questions and comments. Would anyone like to get us started? Sure, Ralph, go ahead.
I have maybe just a conceptual question.
Those are my favorite kind, Ralph, you know that. I said those are my favorite kind, you know that.
No, you also know the law, I only can do the logic. So you distinguish between three types of acts, which seems helpful, but which seems to place a lot of weight on kind of the nature of the act, and to some extent defines in these first categories what the outcome is in the end. Somewhat. I wonder whether it wouldn't make more sense to disentangle what we mean by attribution. Because attribution, that's always been something that puzzled me, and I think it's something that puzzles you too, does two things, right? One is it creates liability for the state in addition to the individual, and that's a kind of a transferring effect. And the second is it may discharge the individual from responsibility because we attribute only to the state, right, in agency law. That's the second aspect. And it seems to me that in using the word attribute, we don't distinguish between those two possible effects that attribution can have. It can have one of the effects, it can have the other effect, or it can have none, and then we don't have attribution, then we're in your third case. My proposal is just to think through whether distinguishing between effects of attribution, which comes down effectively to the same types of cases that you have, maybe analytically closer to what you're doing, which is looking at attribution types rather than at act types. So really that's just a suggestion more than a question.
Thanks, that's very helpful. And just 2 words on that, which is that the draft articles of state responsibility in Article 58 specifically say that everything they say about attribution used in their terminology, which is the first, creating liability for the state, is without prejudice to anything in the second category, which is discharging the individual. So thinking about, I mentioned Article 58, but thinking about the fact that then it means that just looking at the draft articles does not tell us one way or the other whether the fact of attribution under the draft articles has any role in discharging or not the individual. So, that's useful. Thank you.
Julian.
Yeah, thanks. As usual, I'm always daunted by talking about this topic because you obviously thought about this like 1,000 times more.
Too many times.
I ever have.
Not as much as the
I was thinking about this, but I was really struck by Dean Rutledge's comments from Georgia that about the analogy in other areas of law. And so, like, I was thinking, I've taught corporate law before, and or agency law, which my students absolutely hate because it's very confusing to me and thus to them. But one interesting thought about agency law, one idea of it is for corporations or just agency in general, is that the principal, it's unfair to hold the agent liable or the principal liable for something the agent's doing that's outside the principal's authority. But on the flip side, where the agent's acting with authority, you should go up to the principal, and in some sense not the agent, right? So I wonder if, and then the principal can go after the agent, I suppose. There's this doctrine of apparent authority where, everyone thought he was acting on behalf of the agent, and the principal let everyone think he was acting on behalf of the agent, but he wasn't really acting on behalf of the agent, on behalf of the principal. And so we go after the principal anyways, and the principal has to go after the agent. I wonder if that concept is useful here, because it seems like otherwise you get two bites of the apple, right? You attribute liability to the state through attribution principles, but then you can still go after the agent as well, which seems a little odd if you think about it that way. You're really getting both. And what work is attribution really doing here other than making sure everyone goes down together? But I wonder if the older concept would be that you would use the principle to make sure the state is on the hook for what the agent has done. And the old idea is then the state will go after the agent right down the road for the things that the agent did that they shouldn't have done. But the state is ultimately responsible in the same way the corporation or the principal is responsible. If it's really done on behalf of the corporation's responsible for it. Why then do you hold the agent responsible as well? Same thing, the state's really responsible for what the agent's done. Why do you then hold the agent responsible as well? Unless it's for the reason of trying to give the agent additional incentives to sell out the principal. But it does seem a little why wouldn't you rely on if you impose liability on the state, and then the state can go after the agent if the state wants to, but it does seem a little unfair to go after the agent, I guess. Isn't that? I wonder if that kind of thinking seems too foreign to the language of drafting the ILC conversations, because I think you've identified in category 2 the weird situation where we're going to get both, right?
That's very helpful, and I've tried to engage a couple of corporate lawyers in conversations on this topic with not a whole lot of success due to my own shortcomings, not theirs. But I think, briefly, because I know we want to get to your presentation, dual responsibility, right? I mean, joint and several liability is something we're very familiar with in tort law, right? So I understand your concerns about dual recovery, but I don't think the answer to that is to suggest that responsibility is that individual responsibility and state responsibility are mutually exclusive. So, one of the ways that some of the members of the House of Lords have squared that circle is to say, well, look, criminal proceedings don't impede the state. So, go ahead with the criminal proceedings, that's fine, there's no effect on the state. Now, I actually, some capacious conceptions of real party and interest would suggest that criminal proceedings also, if they're about conduct performed on behalf of the state, have some effect on the state. So that's why I'm a little suspicious of the civil-criminal distinction. But the notion being, right, perhaps most simply in the criminal context, there can be state responsibility, and that can coexist with individual criminal responsibility and punishment. So then the question becomes, well, in the case of civil recourse, does recovery against the individual official, again, assuming the individual official bears personal responsibility, because if not, then that would be unfair, and I think the defense there, as in the commercial transactions context, is I don't bear personal responsibility. So not that I'm immune, but that there's no cause of action against me because I don't bear personal responsibility for this act. Where the individual does bear personal responsibility, I think maybe on the procedural side of things, we would ask about questions such as, this whole field that maybe some of your students will go into on insurance litigation, right? There's always insurers and reinsurers. I mean, who ultimately pays ends up being decided often down the road, or even in this Tanzania case we heard about this morning, where it's the Tanzanian government ultimately that paid for the misdeeds as an ex gratia payment, not as pursuant to judgment. But nonetheless, I think there is an interplay there, which is precisely the reason that some people say there should be civil immunity even if there isn't criminal immunity, because at the end of the day, the state's going to pay one way or the other. I think they're less worried about dual recovery, but they say, well, the state will indemnify the official, or you're just going against the official because you can't go against the state because of state immunity, so this is an end run. And I guess, again, my intuition, that doesn't mean I'll necessarily persuade you of it, but that we have a lot of existing doctrines to deal with problems of dual recovery and indemnification and all of that. That in and of itself is not a reason to go to the prior step, which is there actually personal responsibility here?
Yes, Elizabeth.
I just would like to follow up on that comment and kind of bring it back, bring it to another context that would shed a little bit of light on and maybe relate to the question of the abstractness of the point about the state's existence, it seems like it's not a precise analogy to take agency law in a corporate setting and then apply it to the state, the state-agent relationship, because in agency law there's an actual, well, in a corporate agent, you could have a corporate principle that is somewhat analogous to the state. But let's say it's, there's a principal. I'm a principal, and someone is acting on my behalf. I have my own agency, and the principal, the agent has their own agency. But say in a situation where, for example, U.S. officials who may have been involved in planning torture of detainees in the war on terrorism, which is how I got into this whole subject to begin with. They may not. There may have been a plan to carry out illegal acts that was fomented at a level that didn't go all the way up to the head of state, and yet those individuals were not acting out of some kind of personal or some sort of personal sadomasochism. They were acting on behalf of their view of what the state wanted them to do. But for the state's existence, they would not have done what they did. And so the double the double responsibility of the agent and the principal there seems to me to get at Justice Jackson's point that atrocities are not carried out by abstract entities of the state, and also, but at the same time we have to remember that the state, even where lower level officials are not maybe keeping higher officials out of the loop, those higher officials are not the state either. They are different agents of the state, which doesn't really exist but for those officials.
We're learning lots more about, and Andre Nulkamper and others are theorizing dual attribution in international law generally. And so, for example, the Mothers of Srebrenica case in the Netherlands didn't involve, well, I think actually they're talking about prosecutions of I think a couple of individual commanders now but initially the question was, a group brought suit against both the United Nations and the Dutch government in Dutch courts. So the Dutch government didn't have any domestic immunity doctrines maybe, but not international immunity doctrines. The United Nations was held immune, but that did not preclude recovery against the Dutch state. So, maybe also Julian's point that courts in a variety of circumstances have recognized that the immunity of one party that bears responsibility, it can coexist with the responsibility, liability, and ultimately payment of a judgment by another party that may share responsibility.
So we're out of time, and we need to take a bit of a break before the next panel, so please join me in thanking Professor Keitner.